Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, we have reached the summer recess for the United States Supreme Court, and they spent this week taking a wrecking ball to a lot of progressive pet projects. Now, we're not going to talk about any of that, but we are going to talk about the other big news that come out of the United States Supreme Court today, which is that they have accepted review for next year's term of a huge Second Amendment case. And this case is a loaded one, and it's going to be a very difficult one, and I'm going to explain why. So today, let's spend a few minutes and let's talk about the Supreme Court accepts review of its toughest gun case yet. Okay, so the case that we're talking about today, and we have talked about it before, is the case of United States v. Rahimi. Now, what's the background on this case? The background is that Mr. Rahimi is an a-hole, allegedly. Mr. Rahimi, who had all sorts of charges against him, of which some of them were violent in nature, and therefore there were a pre-trial conditions of release, pre-trial orders issued against him upon findings of probable cause that he could not have access or possess any firearms. Of course, that didn't stop Mr. Rahimi from going on a shooting spree with firearms, which of course he was unlawfully possessing at that time. Now, charges were brought against Mr. Rahimi for being an ineligible person, being in possession of firearms under federal law due to the indictments against him. His defense team, and this is the interesting thing about this case, frequently when we see a case get all the way to the United States Supreme Court, we have Firearms Policy Coalition, Gun Owners of America, Second Amendment Foundation, somebody like that spearheading it. That's not what's happening in this case. What we have is Mr. Rahimi's defense team on their own is managing to do this, and they're doing a really, really good job. Now, here's the thing I want you to be aware of, and this is something for the lawyers out there. I'm sure that your law professors have taught you this as well. There is an adage that bad facts make for bad law, and if ever there is a case full of bad facts, which could turn around and turn into bad law, even with this United States Supreme Court, it very well may be the United States v. Rahimi. Now, when we go back in our little time machine and we take a look at how the Fifth Circuit struck down this portion of 18 U.S.C. Section 922. So that's what the remedy was out of the Fifth Circuit, which is why the United States government crapped its pants and immediately filed for review by the United States Supreme Court. Now, when this case was before the Fifth Circuit, Rahimi's lawyers argued that, in fact, there was no historical analog that justified this type of restriction. And if you are looking for some type of a historical analog akin to what's happening here in 18 U.S.C. Section 922, we can't find any, okay? Because what we're looking for here, if you're looking for an identical twin, is going to be some type of really old law that prohibited a person from possessing a firearm based upon a criminal allegation against them. Now, that's not what makes the case difficult. Here's what does make the case difficult in addition to the bad facts, is that there actually is a very, very long and rich history and tradition in the United States going way back before ratification of the Constitution, going back before even the Declaration of Independence, going all the way back to the colonial times of the 1600s. There is law after law after law on the books that restricted access and possession of firearms by people who society deemed to be dangerous. The list is long. Literally every state and or colony that was in existence during that time had laws on the books to do it. Now, here's the problem, and this is where the United States finds itself in its conundrum, and where the court is going to find itself in this conundrum also, is that every single one of those laws that I previously referenced, going all the way back to 1642 in Virginia, we talked about all of them on this video right here. Well, they did one thing, and they did one thing only. They prohibited possession and access to firearms that society deemed dangerous, but those individuals were deemed dangerous based on one of two criteria. Either A, the color of their skin, African American, Native American, or two, religious beliefs, okay? And that's it. And you can go back in every single state Every single state on the eastern seaboard has laws on their books, many of them going all the way up through the 1860s, by the way, that prohibited possession of firearms by African Americans, by Native Americans, by Catholics, and other religions. So, to the United States government, there is a rich history and tradition of restricting firearms, somewhat akin to what you're doing in Rahimi. Society deems people like Rahimi to be dangerous. Now, the difference between how society looks at Rahimi today is that's actually based on Rahimi's actual physical behavior and performance, all right? We have a sample size of what Rahimi is like in public, and it doesn't look good. When we talk about the historical analogs that existed in the United States in the 1600s, 1700s, early 1800s, well, that's based on stereotypes and blatant racism. So while the subjective reasons for which they reach that conclusion may be different, the objective belief that this person falls into a dangerous category of individuals and therefore should not be permitted to have access to firearms, there is the historical tradition in doing that. And that's what makes Rahimi so difficult. There is another fallout, which is that this has the ability to overturn all sorts of pretrial domestic violence weapon surrender orders. And we know, for any of you who've ever practiced in local criminal courts on the state level, you know how feverish prosecutors and judges try to get firearms surrendered after an allegation of domestic violence. So this has incredibly far-reaching implications, and unfortunately, to really do the proper analysis, the government's attorneys, Rahimi's attorneys, and all 9 justices on the Supreme Court, well, they're going to have to pull the Band-Aid off a very nasty scab in the history of gun control, and that is its very racist origins. The case, once again, is United States v. Rahimi. It is set to be argued sometime next term before the United States Supreme Court. Obviously, when the briefs start dropping and all that, we'll do some more videos. In the meantime, if you got any question about this case or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.